under Canadian federal tax law, there is a provision that can shelter well over $1 million in capital gains tax on the sale of qualifying small business shares. Over $1 million sheltered from tax. Most Albertan owners have heard about this, although very few understand it and don't understand if they actually qualify or how it works. And even fewer have taken the legal steps to make sure their business is ready for it. In this episode, I am going to talk to you about this provision and what you need to do in advance now to make sure your business qualifies in the future. You've done the work. Your corporate records are clean. You've discussed the lifetime capital gains exemption with your CPA. You understand what your business is likely to be valued at and why. And you're ready to go to market. So what happens next? Who finds the buyer? How does your information get into the market without getting into the wrong hands? What do you sign and when and with whom? Episode 5 is the go-to-market episode. This is where the sales process becomes real and where the decisions you make in the first few weeks can either create competitive tension around your business or subtly signal to potential buyers that you don't really know what you're doing. I'm Chad Graham. I'm a corporate commercial lawyer in Edmonton, Alberta, and this is From Build to Sold. If this is your first episode, welcome. You can see the whole playlist by clicking on the link in the description. But today we're covering this go-to marketing process. We're going to discuss your intermediary options, how the buyer search actually works, and the one legal document that you must have before you share anything meaningful with anyone. So let's jump right into it. Most business owners don't go directly to a buyer on their own. They use an intermediary. Option 1 is a business broker. They handle transactions typically in the range under $5 million or so. They work on a success fee, a common formula or percentage flat fee that might work out to 8 to 12%. They're going to bring a buyer database, deal experience, and the ability to run a structured process, and they can be an invaluable asset. But there's something important to know. In Alberta, they are not a regulated profession. They don't have any particular certifications needed. And so you're going to rely heavily on their reputation and their track record, and specifically their track record in your industry. And of course, your gut. Ask for the references. Ask how many deals they've actually closed, not just listed. If the business is a little bigger, you might be looking at an M&A advisor or even a boutique investment bank. These are going to be much more tightly controlled processes. They're going to prepare comprehensive marketing documents, approach a curated list of strategic and financed buyers. And they're going to try to maximize your competitive tension. The other fees are going to typically be higher, but their process is going to be more involved. And for a business of sufficient size, this additional rigor and broader buyer reach can have really great benefits. However, for many Main Street businesses, sales happen off-market. The owner knows someone in the industry. Maybe there's a relative or a key employee, or a competitor approaches them, or a supplier wants to make an acquisition. In these situations, there can be no middleman at all. Just the owner, the buyer, and their respective advisors, if any. These off-market deals can be efficient. They happen all the time, and they are reasonable. But they do typically lack that competitive tension. And where there's only one buyer at the table, after all, they know it, and they're going to price accordingly. So if you're in a direct discussion with a single buyer, you want to have a lawyer who understands deal dynamics. It will be more important than ever. Another distinction to be really clear on is buyers and sellers representatives. If a buyer approaches you with their own M&A advisor or broker, or a seller approaches you as a potential buyer, remember that that advisor works for them and not for you. They've already gone through the process of taking on that advisor and assessing their place, so they know what they're doing. They're sophisticated. They know the process. You need your own team. You need your own legal counsel at a minimum, and ideally your own financial advisor if the business warrants it. Now, before you share anything meaningful as a seller with that potential buyer, like your financials, your customer information, your key employee details, your operational data, you need a well-drafted non-disclosure agreement, an NDA. Now, this seems obvious, but there's two things I see relatively frequently. The first are people who are in a hurry and seem to have a good relationship with the person they're selling to, so they just skip it. But goodwill is not a legal protection, and a handshake will not prevent a competitor from stealing your customer list. The second is signing a buyer's DNA as a seller without really understanding it or having your lawyer go through it with you. A sophisticated acquisition entrepreneur is going to have their own template, and this might not be a bad thing, but it's going to be general and it's going to be designed to protect the buyer's interests. They may contain mutual confidentiality provisions that will limit what you can say about a failed negotiation. They may have narrow definitions about confidential information that leave meaningful gaps. They may carve out information the buyer already possesses through other means, and this can be broader than you expect. So you want to have your lawyer review that NDA, and actually even better, because you know your industry and your business better than anyone, you and your lawyer should actually draft your own sections or your own NDA to use. What should win these NDAs? Well, a clear, broad definition of confidential information. It needs to cover your financials, your customer supply relationships, your employee information, your operational data, and general information they might receive about your trade. You need a permitted use restriction. This is only for the purpose of assessing the business and nothing else. You need a non-solicitation provision. You don't want them going through this process just to get access to your employees or customers. You need a standstill provision that prevents the buyer from making any direct approaches to any of your key relationships while discussions are ongoing. And then, of course, you need a return or certified destruction section that any documents they look at, if the deal doesn't proceed, will get back to you. And they have a reasonable term. Typically, I see these as about 2 years. Now, NDAs are governed in Alberta by common law contract law. There's no specific Alberta statute, which means precision is everything in drafting. A poorly worded or vague NDA has very little power in the courtroom. So you've got this all together. You have a potential buyer. You guys have signed your NDA. Now the process begins. If you're using a broker or M&A advisor, they will prepare something called a Confidential Information Memorandum, or a CIM. This is a detailed marketing document that describes your business, its history, its operations, its financial performance, its management team, its growth opportunities, and the terms on which the business is being offered. Before this goes to market, read it carefully. Remember, everything in it is going to be confirmed in due diligence by accountants and lawyers and business experts. This is not marketing copy. You will look like a professional who knows what you're doing if you have accurate numbers, and it will lead to a better result in the end. Now, not everyone who expresses interest in your business needs to see this CIM. You know, there are people fishing for information. There are the proverbial tire kickers. And there's buyers that maybe would like to make an acquisition, but when the rubber meets the road, they're not going to come up with the financials to do it. So before you share your CIM with anyone, confirm they have credible financial capacity, proof of funds, a financing pre-qualification letter, or a demonstrated track record of similar acquisitions, and make sure they've signed that NDA. Now, one item Alberta business owners often miss here, now that we're into this process, is privacy law. When you share employee information, for example, their salaries, their employment records, their HR files, with a prospective buyer during this due diligence process, you are disclosing private information about these employees. And in Alberta, that's protected by Alberta's Personal Information Protection Act, or PIPA. The disclosure of these bits of information during a business sale due diligence process is typically allowed, but it must be proportionate, limited to what is necessary, and subject to appropriate confidentiality protections. That's why this is a key part of what needs to go into your NDA. Now, having all of these concerns that we've talked about are no reason whatsoever to avoid the process. They're just reasons to manage it with appropriate care. So let me be specific about the legal work that you'll want to have happening during and through all of these pre sale steps. Typically, people think of the lawyer as what you bring in the end when you're signing the documents, but by then it's too late to fix many of these early things. So a lawyer can come in and help you with reviewing and drafting your own NDA to be ready for any potential buyer's offer. They can review the broker or M&A's advisor engagement letter, which is a contract with real consequences, including the success fee, the tail period that most people don't notice about when a fee is payable even after the engagement ends, and exclusivity provisions. They are reviewing your key contracts for assignments and change of control clauses before those contracts go out as data for review. And your lawyer is available to advise you on any buyer approaches that you feel are unusual or that raise questions about legitimacy. A lawyer engaged early in the process is not a cost. They're a risk management tool for the most significant financial transaction most business owners will ever undertake. Going to market is your moment. All the years of preparation have become live. The intermediate you chose, the NDA you present, the buyer you qualify, all of these decisions shape the outcome before a single offer is ever made. And in the next episode, we're going to start looking at that offer with a document many sellers treat as a formality, but that I understand to be one of the most consequential documents in the entire process, the letter of intent, or LOI. This document looks non-binding, but it binds you in more ways than most people realize, so don't skip it. If you want to talk about the process and your preparation and where you're at today, and you're eager to get a hold of your own broker, then visit chadgrahamlaw.com and book a complimentary consultation today. And we'll see you in episode 6.